My daughter didn't close the bedroom door. I heard her conversation with her husband. A couple more months and Mom will sign everything. She's so trusting, they laughed. What they discussed next about getting rid of her made me. Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end and let me know which city you're listening from. That way, I can see how far my story has traveled. The house on Clover Lane had been mine for 31 years. Harold and I had bought it together in the spring of 1993, back when the maple in the front yard was still a sapling and the neighborhood smelled of fresh asphalt and young ambition. We raised Linda there, watched her ride her first bicycle down that cracked sidewalk, helped her pack boxes for college from the same hallway where her height mark still lived in pencil on the doorframe. When Harold died of a heart attack in 2019, I thought the house might swallow me whole with its silence, but it didn't. I learned to fill the rooms myself, with books, with the hum of the radio in the kitchen, with the slow and decent rhythm of a woman living alone and not minding it as much as people assumed she should. I want to be honest about who I was before all of this happened, because it matters. I was not a naive woman. I had worked 22 years as an office manager for a dental practice and had handled payroll, insurance disputes, and the particular cruelties of health bureaucracy without flinching. I was careful with money. I had a modest savings account, a paid-off house worth somewhere around $340,000 according to the last county assessment, and a small but reliable pension from Harold's years at the plant. I was not rich, but I was comfortable, and I was independent, and I had believed, truly believed, that this was a source of quiet pride for my daughter. Linda had moved back to Columbus with her husband Craig 4 years after Harold passed. She said it was because she wanted to be closer to me. Craig had lost his job in Pittsburgh, something in logistics, something I never fully understood. And Linda had found work at a marketing firm downtown. They stayed with me for 2 months while they found an apartment, and I had been glad to have them. The house felt less like a tomb with footsteps in it. I cooked Sunday dinners. Craig fixed the gutter that had been sagging since February. It seemed for a while like something good. The first sign, if I am honest, was not dramatic. It was a Tuesday in March, almost 2 years after they'd settled into their apartment on Fenwick, when Linda sat across from me at the kitchen table with a yellow notepad and suggested I think about adding her name to the deed. Just for ease, she'd said, keeping her eyes on the pad as though the idea had been arrived at casually, the way you might suggest rearranging furniture. If something happened to you, it would make everything so much simpler. I told her I had a will. She nodded and didn't press it, but she wrote something down on the notepad, and I remember thinking, why is she writing something down? I let it go. That is the truth. I let it go because she was my daughter, and I loved her, and because entertaining the alternative, that she was calculating something, felt like a kind of madness I wasn't willing to step into. But the suggestions kept coming, spaced out carefully, never clustered close enough together to feel like pressure. In May, Craig mentioned a financial advisor he wanted me to meet. A real sharp guy, he'd said, helps a lot of older folks get their affairs in order. I declined politely. In August, Linda brought over a stack of papers about living trusts and left them on my coffee table as though they were magazines. In October, she mentioned again, gently, the deed. And then there was the power of attorney. That conversation happened over lunch at a restaurant called Hartley's, the kind of place with cloth napkins and soft lighting that makes difficult things feel civilized. Linda had ordered the salmon. She explained, in the careful, rehearsed tone of someone who has practiced in the car on the way over, that it would be best if she had the legal authority to act on my behalf in case of emergency. She used the word emergency 4 times. Craig nodded along from across the table, cutting his steak with small, precise movements, saying nothing, but watching me in the particular way of a man waiting for a verdict. I told them I would think about it. I was not alarmed. Not yet. It had all seemed, in the moment, like the anxious love of adult children watching a parent age. I had seen it happen to friends of mine. The slow, well-meaning takeover, the hovering, the gentle erosion of autonomy dressed up as care. I thought perhaps that was all this was. That changed on a Thursday evening in November. I had come upstairs to ask Linda something. They were staying the weekend. The apartment was being painted, and her bedroom door was pushed only halfway closed. I raised my hand to knock, and I heard Craig's voice first, low and easy, the voice he used when he thought no one of consequence was listening. Another couple of months and she'll sign everything. She's so trusting. And then Linda laughed. Not a nervous laugh, a comfortable one. I stood in the hallway with my hand still raised and the floor cold beneath my feet, and I listened to them discuss what they called getting rid of the financial advisor I had been using for 6 years. They mentioned the house. They mentioned the account numbers, as though they had already been memorized. They mentioned a timeline. I lowered my hand. I walked back down the stairs without making a sound. I sat down in Harold's old chair in the living room, and I stared at the maple tree through the front window, and I thought, how long has this been going on? I did not sleep that night. I lay in my bed and I went back through every conversation of the last 18 months, the way you reread a letter after you've learned the writer was lying, finding the false notes everywhere. In the careful pauses, the repeated phrases, the way Craig always looked at the bookshelves when he talked to me, as though cataloging. How trusting she is. Was that what they saw when they looked at me? Not a woman. Not a mother. A property with a signature problem. By 3 a.m, I had moved to the kitchen table with a legal pad of my own. I wrote down everything. Not in a panicked, illegible scrawl. I was deliberate, because if I was going to do something about this, I needed to be clear, and clarity required slowing down. I listed every document they had asked me to sign or consider in the past 2 years. The deed, the living trust pamphlets, the power of attorney. I listed the name of the financial advisor Craig had recommended. I had written it on a notepad at the time, never called, but the name was in my address book. A man called Dennis Farr. I did not know if Farr was involved in any of this or simply a convenient introduction, but I wrote the name down. I listed what they knew. They knew the house's approximate value. Linda had been present when the county assessor's letter arrived, and I had shown it to her without thinking. They knew I had a savings account at First Federal. They knew the name of my attorney, a man named Gerald Hutchins, who had drafted my will after Harold died. They knew I had a pension. They did not know, I was almost certain, the exact balance of my accounts or the specific terms of my will. Almost certain. 3 months ago, that phrase would have been enough. Now, it felt like a crack in a dam. By 5 o'clock, I had made a different kind of list. What I still had control of. The accounts were in my name only. The deed was in my name only. My will named a distant cousin and a local hospice charity as beneficiaries, not Linda. A decision I had made quietly after Harold died and never mentioned. I had not yet signed anything. The relief of that fact was brief and cold, like stepping into shade on a hot day. I had not signed anything yet, but they had a timeline. They had said so themselves. Fear is a strange thing when you're 72. It doesn't arrive the way it did when I was young, hot and fast, like a near miss on the highway. It arrives slowly, settling into your joints, making everything heavier. I sat at that kitchen table in the gray pre-dawn and felt it fully, and then I made a decision that I believe saved me. I chose to be afraid and to act. Not instead of being afraid. Alongside it. Linda and Craig came downstairs at 8. I had already made coffee and set out toast, and I smiled at them, with the ease of a woman who had slept well. Craig talked about football. Linda asked if I needed anything from the store. I said I didn't think so. I watched them over the rim of my coffee cup, and I understood, with a clarity that surprised me, that I had one significant advantage. They thought I didn't know. They left after lunch, and I waited until their car had turned the corner before I picked up the phone. I called Gerald Hutchins first. Gerald was 70 himself, semi-retired, with a voice like a patient schoolteacher. I had not spoken to him in over a year. I told him I wanted to review my will and discuss a few changes. He asked if I was all right. I said I was, and that I simply wanted to be thorough. He scheduled me for the following Wednesday. Then I drove to First Federal, not to the branch Linda had accompanied me to. There was a branch on Morrow Road, on the other side of town, one I rarely used. I sat down with a young woman named Priya at the accounts desk, and I told her I wanted to review the beneficiary designations on my accounts and ask about adding additional security protections. Priya was professional and careful and did not ask unnecessary questions. By the time I left, I had requested account alerts for any unusual activity and had noted which documents would be required for any third party to access my accounts. Then I sat in my car in the First Federal parking lot and looked out at the gray November sky, and I thought about what came next. The house was the core of it. Whatever they were planning, the house was the prize. And a house is a matter of public record. The deed, the transfers, every lien and title. Which meant their plan, whatever it was, would eventually require paperwork. And paperwork left traces. I thought about my neighbor, Eleanor Marsh, who was 81, and whose son had been caught 3 years ago attempting to forge her signature on a refinancing document. Eleanor had caught it only because her bank had sent a letter to the house. The son had been charged with elder financial fraud, a felony in Ohio. He had eventually pleaded to a lesser charge and paid restitution, but the process had been long and painful. I had sat with Eleanor through some of it. I knew what it looked like. I knew now what I was dealing with, and I knew I needed to be careful and thorough and patient. But I also needed to move. I had my first plan. It was not complex, because the best plans rarely are. Protect the assets. Document everything. Find out what they already had access to. And do not, under any circumstances, let them know that the woman they had been managing so carefully had been listening at a half-open door. Gerald Hutchins had his office in a converted Victorian on Broad Street, the kind of building that made you feel, upon entering, that you were being taken seriously. His assistant, a man in his 40s named Paul, who wore reading glasses on a chain and smelled of good coffee, showed me into the back office at 10:15 on a Wednesday morning, and I sat down across from Gerald and told him everything. He listened without interrupting, which I had always appreciated about him. He was the kind of man who understood that silence was a form of respect. When I finished, he removed his glasses and set them on the desk and said, "Peg, I want you to understand that what you're describing, if it progressed to the point of signature, would constitute elder financial exploitation under Ohio law. It's a first-degree felony when the value exceeds $100,000. "I know," I said. "Eleanor Marsh?" "Yes," he said. He put his glasses back on. "Nothing has been signed. That's important. Let's make sure it stays that way." We spent 2 hours together. At the end of it, I had done the following: amended my will to explicitly exclude Linda and Craig from any inheritance with language Gerald described as iron, leaving the house and the bulk of my estate to a revocable living trust with a neutral institutional trustee, a local bank's trust department, rather than any individual. I had signed a durable power of attorney assigning that same institution, not any family member, as my legal decision maker in the event of incapacity. Gerald would retain copies of everything. A second set would go to a fireproof box at the bank. If they present you with documents, Gerald said as I was leaving, tell them you'll have your attorney review them first. That phrase alone will slow most things down. I drove home feeling something I had not expected. Not relief exactly, but solidity, as though I had placed both feet on firm ground after a long walk on ice. I did not know, as I pulled into my driveway that afternoon, that Linda had already noticed something had shifted. She called that evening. Not unusual in itself, but the tone was different. Lighter, almost performatively casual, in the way of someone probing without wanting to seem like they're probing. She asked how I'd been spending my week. I told her I'd had a few errands. She asked if everything was all right, with the house and everything. I said the house was fine. A pause. Then, you haven't been talking to anyone? About finances, I mean? I only ask because I worry. I'm perfectly well, Linda, I said. Did you want to talk about something specific? Another pause. No, she said. Just checking in. After we hung up, I sat very still for a moment. She was checking the perimeter. Something had given her reason to look. I thought about it carefully. I had gone to a branch of First Federal she didn't know I used, but it was possible she had called my regular branch to ask about something and been told my account had new activity protections. Or perhaps Craig had spoken to Dennis Farr, who had perhaps made some preliminary inquiry and found a door that now appeared differently than it had. I didn't know. But the call told me something useful. They were paying attention, and the window I had was shrinking. The direct evidence came the following week, and it came from a direction I had not anticipated. I had asked Paul, Gerald's assistant, to do a title search on my property as a precaution, to confirm there were no liens or encumbrances I was unaware of. This was routine, Gerald had said, and it would take a few days. On a Thursday afternoon, Paul called me. Mrs. Collins, he said carefully, Gerald wanted me to contact you directly. The title search came back, and there's something you need to know. In October, 2 months before the night I'd stood in the hallway, someone had submitted an inquiry to the county recorder's office requesting a copy of my deed and the full title history of the property. The request had been made under a name I didn't immediately recognize, a company called Meridian Property Solutions, LLC. Paul read me the registered agent of Meridian Property Solutions. The name was Craig Allen Hooper. I remember the exact feeling of that moment. Not surprise. The surprise had been spent weeks earlier, in the hallway. What I felt was something colder and more clarifying. The way a fog lifts off a landscape and reveals the topography you'd been walking through blind. He had formed a company. He had been researching the title. He had been doing this not as a son-in-law with wandering ambitions, but as someone who had already taken formal steps. This was not a plan in formation. This was a plan in progress. I thanked Paul and asked him to send me everything in writing. Then I called the only person I could think of who would know what Meridian Property Solutions, LLC, was actually designed to do. His name was Martin Greer, and he had been Harold's attorney for business matters years ago, a transactional lawyer, the kind who understood how shell companies worked and what they were typically used for. I had his number in the old address book I kept in the desk drawer. He answered on the third ring. I told him what Paul had told me. He was quiet for a moment. An LLC with your son-in-law as registered agent, researching the title history on your home, he said. Peg, has anyone approached you about selling the house? Not directly, I said. Have they asked you to sign anything that would allow them to act as your agent in property transactions? They've been pushing for power of attorney. Another silence. Then, don't sign anything, and I'd like to see those documents from the title search. I had asked myself that night in November in Harold's chair how long this had been going on. Now I had a partial answer, at least since October. Perhaps longer. Perhaps since the first time Linda sat across from me at the kitchen table with her yellow notepad. The thought did not break me. It focused me. Martin Greer met with Gerald Hutchins on the following Monday, and the two men, between them, assembled a picture that was uncomfortable in its clarity. Meridian Property Solutions had no public business history, no listed clients, no website. It had been registered with the state of Ohio 8 months ago, 5 months before the title inquiry. The registered address was a mailbox service in Westerville. Based on the structure Martin described to me, it appeared designed to act as a vehicle for a property transfer, the kind of arrangement sometimes used to quickly flip a title, particularly if the seller was elderly, isolated, or legally incapacitated. In plain language, Martin said over the phone, his voice precise and without inflection, if they had obtained power of attorney over your affairs, Craig could, in theory, have transferred the property to the LLC on your behalf. It would have had the appearance of a legal transaction. And then they would own the house, I said. And then they would own the house, he confirmed. Gerald had filed, on my behalf, a formal advisory notice with the Franklin County Adult Protective Services, not a criminal complaint, but a protective record, establishing a documented timeline should any further action become necessary. He had also registered a title lock on the property, a relatively new protective measure available in Ohio that required additional verification before any deed transfer could proceed. I had not yet confronted Linda or Craig. I had not told them I knew. That was intentional. But the plan, as I began executing it piece by piece, had consequences I should have anticipated. It was a Friday evening, 2 weeks after the title lock went into effect, when they came. I had not expected them. Craig's truck was in my driveway at 6:15, and both of them were on my porch before I reached the front door. Linda's face was the controlled expression of someone managing a great deal of feeling very tightly. Craig was less controlled. His jaw was set and his eyes moved around me when I opened the door, scanning the hallway behind me as though checking for witnesses. "We need to talk," Linda said. I let them in. I made no offer of coffee. We sat in the living room, Linda and Craig on the sofa, me in Harold's chair. And Craig leaned forward with his elbows on his knees and said, without preamble, "We know you've been to a lawyer. We know you changed your will." I looked at him steadily. "Who told you that?" "It doesn't matter. What matters is that you did it without talking to us. After everything we've done." He stopped himself. Started again, more carefully. "Mom has been trying to help you. We both have. And now you go behind our backs and—" "Craig," I said, "I am not required to discuss my estate planning with you." Linda's eyes filled with tears on schedule. "Mom, we're only trying to make sure you're protected. You're alone. You're getting older. What happens if something happens to you?" "Then my attorney handles it," I said, "as I've arranged." The tears did not fall. Linda blinked them back, and something else came into her face. Something harder. "We know about the title lock," she said. "Why would you do that? What do you think we are?" I did not answer. Craig stood up. He was not tall, but he occupied space aggressively, and the standing was meant to feel like a change in the weather. "Listen to me carefully," he said, and his voice had dropped to a register I had not heard before. "We have been very patient with you, very patient. But if you make things difficult, if you try to cut Linda out of what's rightfully hers, you're going to find out that family court has a lot of opinions about the mental competency of people your age who make sudden changes to legal documents." There it was. I had been waiting for it, and it landed exactly as I'd expected. cold and precise, designed to destabilize. He was threatening a competency challenge. If they could convince a court that I had been of unsound mind when I changed my will, the changes could theoretically be reversed. I let the silence sit for a moment. Then I said, "I'd like you both to leave my house now." "Peg," Craig started. "I'd like you to leave," I said again, "or I will call the police and report that you are trespassing and making threats." I kept my voice even. "I have documentation of this conversation." That last part was a slight exaggeration. I had not been recording. But neither of them knew that, and the word documentation visibly affected Craig. His shoulders dropped a fraction. Linda stood. She looked at me with an expression I had never seen on her face before. Not grief, not anger, but something cold and assessing, as though she were recalculating. "You'll regret this," she said quietly. "Perhaps," I said. "Goodbye, Linda." They left. Craig's truck reversed out of the driveway too fast, and the tires made a sound on the street that I would remember for a long time. I locked the front door. I sat back down in Harold's chair. My hands were trembling slightly, the way they did after a long drive in bad weather. Not fear, exactly, but the body processing something the mind had already moved past. I thought of Gerald. I thought of Martin. I thought of the title Locke, sitting quietly in the county records like a closed gate. Then I did something I hadn't done in a while. I made myself a proper dinner. Roast chicken from Harold's recipe, the one with lemon and thyme. I opened a bottle of Riesling he'd been saving for something. I ate slowly at the dining room table, which I had set with the cloth placemats, not the paper ones. I needed a few days, not to hesitate, to breathe. The call came 4 days after they had left my living room. It was not from Linda. It was from Linda's friend Tamara, who had known our family for years and who I had always liked. In the mild, uncomplicated way you like someone who is kind to your daughter. Tamara said she was calling just to check on me, that she'd heard I'd been going through some stress, and wouldn't it be nice if we all had lunch together, she, me, and Linda, just to clear the air. She used the phrase clear the air twice in 4 minutes. I thanked her warmly and said my schedule was quite full. After I hung up, I sat with the phone in my lap and thought about what Tamara's call told me. They were regrouping. The direct confrontation had not produced what they'd wanted. I had not been frightened into reversing my decisions, had not offered reassurances, had not invited negotiation. So now they were trying a softer entry point. A mutual friend, a neutral setting, the pretense of ordinary social life. Craig had threatened me with a competency challenge, and I had not buckled. That would have surprised them. People who plan the way they had planned tend to believe their targets will behave predictably. I was not behaving predictably. I did not return Tamara's call. I did not hear from Linda directly for 11 days, and the silence had a texture to it. Watchful, like the quiet before a weather system moves through. I went about my life. I kept my regular Tuesday morning walk in Schiller Park. I attended my book club on Thursday evenings. I had my hair done on Friday afternoons. From the outside, I imagine I looked exactly as I always had, a tidy, pleasant, somewhat reserved woman in her early 70s, unremarkable in the best way. Inside, I was building. The social support, when I found it, came from 2 directions. The first was practical. I called Eleanor Marsh on a Tuesday evening and asked if I could come over. Eleanor was small and white-haired and had a memory like a court reporter. She forgot nothing, felt everything, and expressed both with a precision I admired. I told her what had happened. Not everything, not the legal details, but enough. She listened with her hands folded in her lap, and then she said, "You need a witness, someone who sees you regularly, Someone who can testify that you are sharp, capable, and making your own decisions. She was right. A competency challenge. Craig's implicit threat required evidence of incapacity. The defense against it was exactly what Eleanor described: a consistent pattern of clear, independent behavior, documented informally but reliably across time and social context. My son's lawyer told me afterward, Eleanor said, that the reason they didn't push the competency angle further was because I had 17 people willing to say I was sharper than most people half my age. I started paying attention to that kind of documentation. I continued writing personal checks rather than having bills auto-paid. Each check was dated and signed in my hand, a record of competent financial management. I emailed Gerald once a week, brief notes about nothing in particular, the weather, a book I was reading, so that there was a time-stamped record of coherent communication. I mentioned in those emails that I was well and in good spirits. The second direction of support came from a place I hadn't expected. There was a woman in my book club named Diane Ostrowski, who was 68 and had been a social worker for 30 years before retiring. I had sat next to Diane for 2 years without ever discussing anything more personal than our opinions on the novels we were reading. But one Thursday evening in January, she drove me home because the weather had turned icy. And somewhere between the club and my house, I told her what was happening. Diane did not gasp or commiserate in the automatic way of someone processing shock. She said, "Have you contacted Adult Protective Services directly yourself? Not just through an attorney. Have you spoken to a caseworker?" I had not. Gerald had filed on my behalf, but I had not had a direct conversation. Diane called a colleague the next morning. By the following week, I had spoken with a caseworker named Renee from the Franklin County APS office, a calm, methodical woman who reviewed the file Gerald had started and asked me a series of questions that I understood by the end of the conversation were designed to establish my cognition, my autonomy, and the voluntariness of my recent legal decisions. I answered every question clearly and directly. Renee told me that the case had been flagged as a precautionary matter, and that the documentation was in place should any party attempt to challenge my legal capacity. The title Locke, the amended will, the institutional power of attorney. These are exactly the protections that work, she told me. The challenge is when people don't take these steps until after something has been signed. I had not signed anything. I held on to that. On the 12th day after their visit, Linda texted me a photograph of us from a Christmas perhaps 15 years ago, both of us laughing at something out of frame. Harold's arm visible at the edge of the picture. No words. Just the photograph. I looked at it for a long time. Then I set the phone down, walked to the kitchen, and made tea. They came on a Sunday afternoon in late January, when the light through the front windows was thin and flat, and the maple in the yard had the skeletal look of deep winter. This time, Linda had called ahead, something she hadn't done in months, and asked if they might come over to talk, just the two of us without any of the lawyer stuff in the room. She sounded tired. She sounded like my daughter, which was the most dangerous version of Linda I knew. I said they could come. I want to be precise about why I said yes. Not because I was softening, and not because the Christmas photograph had worked on me the way she'd intended. I said yes because I had spent the preceding weeks building a case, and a case requires knowing what the opposition will do when given access. I wanted to see how they would present themselves. I wanted to see the mask. They arrived with a tin of cookies from a bakery Linda knew I liked, a small, studied gesture. And Craig was wearing an expression of such deliberate openness that it looked almost painful to maintain. We sat in the kitchen this time, not the living room. Linda had asked to sit in the kitchen, and I noticed that and filed it away. The kitchen was softer, more domestic, associated in both our memories with ordinary life. A strategic setting. Linda spoke first. She said she was sorry for the tension, that things had gotten blown out of proportion, that Craig had been under tremendous stress because of work and hadn't meant what he'd said the way it came out. Craig said he was sorry about how the conversation had gone. He did not say he was sorry for the content of the conversation, only for how it had gone. I nodded and kept my hands folded on the table. Then the turn came, and it came through what appeared to be vulnerability. Linda's voice went quiet, and she looked at her hands and said, "Mom, I'm scared for you. I don't sleep because I worry. You're here alone, and you've put everything in the hands of people who don't love you, who don't know you. A bank. Strangers." She looked up. Her eyes were wet again, and this time, a tear did fall. One careful tear, tracking down her left cheek. "We're your family. Whatever happened, whatever misunderstandings there were, we love you. We just want to be part of your life." It was well done. I will give her that. Under other circumstances in a different life where I had not stood in a hallway and heard what I had heard, it might have moved me. "What is it you're asking me to do?" I said. Craig placed a document on the table. He said it was a simple amendment, just adding Linda's name to the account at First Federal as a co-signer, so she has access if you need help. Not the deed, not the will. Something smaller. A first step. I looked at the document. It was 2 pages, and the second page had a signature line already prepared with my name typed beneath it. "I'll have Gerald review it before I sign anything," I said. The air in the kitchen changed. It was subtle. The way a room changes when someone stops performing. "Mom." Linda's voice was still soft, but the texture was different. "Gerald is charging you hundreds of dollars every time you call him. We're trying to help you save money." Peg. Craig leaned forward, and the openness in his face had given way to something more compressed. "I want to be straight with you. If you keep freezing us out, if you keep letting lawyers make your decisions, people are going to start asking questions about whether you're capable of making your own decisions at all. I don't want that. Linda doesn't want that. But people will ask." There it was again. He could not help returning to it. The threat of incompetence proceedings was his only real weapon, and he was using it again now, politely but unmistakably. I thought of Renee at Adult Protective Services. I thought of Eleanor's 17 witnesses. I thought of the weekly emails to Gerald, time-stamped and coherent. I thought of every check I had written, every appointment I had kept, every clear and documented decision I had made since November. "Craig," I said, "I have spoken directly with the Franklin County Adult Protective Services. They have an open case file with my name on it, documenting the series of requests you and Linda have made and my responses to them. If any party initiates a competency proceeding against me, that file will be reviewed as part of the process." The color in his face shifted. "I'm not going to sign this document," I said. "I would like you both to leave." Linda stood so quickly the chair scraped the floor. "You have lost your mind," she said, and there was nothing in her voice now except fury. Clean, unguarded, the mask entirely gone. "You are choosing strangers over your own daughter." "I'm choosing my own judgment," I said. "There's a difference." Craig picked up the document from the table without speaking and folded it precisely and put it in his jacket pocket. The gesture frightened me slightly. It was too controlled, the movement of a man who was recalibrating, not retreating. He paused at the kitchen doorway. "You should think very carefully," he said, "about where this ends." I did not respond. I watched them go. After the front door closed, I stayed at the kitchen table for a long time. My heart was beating quickly, and I noticed that I did not try to slow it down or talk myself out of what I was feeling. The fear was real. The threat was real. Craig was not a man who made idle statements. But here is the thing I understood that he did not. He had shown me everything, both times. He kept revealing the only instrument of pressure he believed he had, which meant it was the only one he had, and I had already built the defenses against it. The fear did not weaken me. It confirmed what I already knew. I was right. This was serious, and I was not finished. Martin Greer had made a discovery in early February that changed the shape of what I had been preparing for. He had been conducting a broader inquiry into Meridian Property Solutions, tracing its incorporation documents, its initial capital, any associated filings. And he found that Craig had not acted alone. 3 months before the company was formed, Craig had entered into a consulting agreement with a man named Philip Dutton, who ran a small real estate acquisition firm that specialized, in Martin's words, in purchasing distressed or probate properties at below-market rates. Dutton's company had twice been investigated by the Ohio Department of Commerce for predatory practices involving elderly homeowners, though neither investigation had resulted in charges. The consulting agreement between Craig and Dutton specified a finder's fee. 10% of the acquisition price of any property Craig brought to Dutton's attention and helped facilitate. My house, at $340,000, would have been worth $34,000 to Craig upon transfer. Martin delivered this information in his office on a Tuesday morning, in a folder he slid across the desk to me with the careful movements of a man presenting something fragile. I read it. I put it down. I asked him what our next step was. "We're going to a different kind of meeting," he said. Gerald, Martin, and I spent 2 weeks preparing. Gerald had been in contact with the Franklin County Prosecutor's Office, not filing charges yet, but making a formal inquiry about the viability of an elder financial exploitation case and receiving confirmation that the elements were, in a prosecutor's words, strongly present. Adult Protective Services Renee was briefed. The documentation, the title search, the LLC registration, the consulting agreement, the recorded series of requests for legal access, was assembled into a coherent file. The meeting was held on a Thursday afternoon in late February, in the conference room at Gerald's office on Broad Street. I had told Linda by text message that I wanted to discuss some family matters with her and Craig, and that I had asked my attorneys to be present since I wanted things to be properly documented. She had texted back a single line, "Fine, we'll be there." They arrived first. I watched them through the glass panel in the conference room door before entering. Craig was talking at Linda in a low voice, and she was staring at the table. And something in the arrangement of their bodies, both slightly forward, both slightly clenched, suggested they were less confident than they wanted to appear. I entered with Gerald on my left and Martin on my right. Renee from APS sat at the end of the table. A court reporter named Susan, whom Gerald had hired to transcribe the proceedings, sat in the corner. Craig looked at the court reporter and said, "What is this?" "This is a documented conversation," Gerald said pleasantly. He took his seat. I sat across from Linda and Craig. I had a folder in front of me, which I did not open immediately. I looked at my daughter for a moment before speaking. She looked tired and somehow younger than her 44 years, sitting in that conference chair in her good coat, and I felt something that was not quite grief and not quite love, but existed in the space between them. Then I opened the folder. I spoke for 12 minutes. I laid out the timeline, the first request to add Linda's name to the deed, the living trust pamphlets, the power of attorney conversations, the formation of Meridian Property Solutions, the title search on my property, the consulting agreement between Craig and Philip Dutton. the 2 previous investigations into Dutton's firm, the nature of the finder's fee. Craig tried to interrupt twice. Gerald said, both times, "Please let Mrs. Collins finish." When I was done, I set down the last page and looked across the table. Craig's face had undergone a transformation that was almost interesting to watch. The way a complicated mechanical thing is interesting when it jams. He started with anger, shifted briefly to something that resembled the beginning of an explanation, and then seemed to lose the thread of which response to commit to. His jaw was tight. His hands on the table were very still, in the particular way of someone controlling them deliberately. Linda looked at the folder. Then she looked at me. Then she said, and I will remember this precisely, "I don't know anything about a consulting agreement." The court reporter's fingers moved. "Linda," Martin said, "that may well be relevant to the question of your individual liability." That word, liability, broke something open in the room. Linda turned to Craig with an expression I recognized from her childhood. She looked like a person who had discovered she was in a place she had not chosen. "You never said anything about Dutton," she said. "Linda," Craig said, "you never told me there was a fee." "This isn't— Did you file the LLC in my name?" Her voice had risen and gone flat at the same time, the specific quality of a person who is afraid and furious in equal measure. Craig stood up and said that this was not the appropriate forum and that nothing being said was legally admissible and that they would be speaking to their own attorney. "Please be seated, Mr. Hooper," Gerald said, "or I will ask you to leave and we'll proceed with those present." Craig sat down. He looked, for the first time since I had known him, small. I folded my hands on the table and said nothing. I did not need to say anything more. I had said what I came to say. I watched him try to reconstruct a position he no longer had, and I felt not satisfaction, not triumph, a kind of weary clarity, the way you feel when you have carried something heavy for a long time and finally set it down. The meeting concluded with Craig and Linda's departure before any formal resolution was reached, which Gerald had anticipated. What happened in the weeks that followed was less dramatic than the meeting itself, but in many ways more consequential. The Franklin County Prosecutor's Office opened a formal investigation into Craig and the activities of Meridian Property Solutions within 10 days of the meeting. Martin had submitted the full file, the consulting agreement, the LLC documentation, the title search, the pattern of requests for legal access, and a deputy prosecutor named Bryce Whitfield called me directly to ask several clarifying questions. I answered each one carefully and completely. Whitfield told me, in the measured language of someone who could not make promises but was being honest, that the case was substantive. Adult Protective Services upgraded the status of my case from precautionary to active investigation. Philip Dutton's name, when it appeared in the investigation, triggered a review by the Ohio Department of Commerce. This was not something Martin had engineered. It was the consequence of Craig's decision to associate himself with a man who was already on a regulatory watch list. Dutton's firm was placed under formal review for the third time, and this time, with the Meridian documents providing a clear paper trail of intent and method, the review had teeth. Craig hired an attorney, a man named Halverson who practiced in Dublin, and for several weeks there was the procedural back and forth of criminal inquiry, subpoenas, document requests, the careful formalities of a process that moves slowly but does not stop. Martin kept me informed without overwhelming me. I had begun to understand the difference between things I needed to know immediately and things I could learn about later. The criminal case, as it developed, revealed two things Gerald had not been certain of before the meeting. The first was that Craig had, in fact, acted largely without Linda's knowledge of the Dutton arrangement. She had been aware of the plan to obtain power of attorney and to have Craig manage my finances. She had been a willing participant in that. But the LLC, the consulting agreement, and the finder's fee had been Craig's private architecture. Linda had believed, it seemed, that she was helping Craig take care of her mother. Craig had believed he was engineering a $34,000 payout and a property acquisition for Dutton at significantly below market value. This distinction mattered legally, though not in the way I imagine Craig hoped it would. Linda's knowing participation in the power of attorney scheme made her liable as a party to the underlying fraud. Reduced liability, yes, but liability nonetheless. She was required to appear before a grand jury in April. She retained her own attorney, separate from Craig's. That separation, Gerald told me, was itself significant. Craig was indicted in May on 2 counts: attempted elder financial exploitation, a first-degree felony, and engaging in a corrupt pattern of activity in connection with Dutton. Dutton himself was charged separately. I received a letter from Linda's attorney in March, a few weeks before the grand jury proceedings. It was a formal document, carefully worded, stating that Linda wished to convey her regret for any distress caused and that she had been unaware of the full extent of her husband's plans. I read it. I gave it to Gerald. I did not respond. Gerald asked me sometime in the spring whether I wanted to pursue any civil action against Linda independently, in addition to the criminal proceedings. I thought about it for several days. I walked in Schiller Park. I sat in Harold's chair in the evenings and watched the maple fill out again. It was April, and the leaves were coming back, and the tree was doing what it had done every year since we'd planted it, quietly and without assistance. I told Gerald no. Not because Linda deserved forgiveness. I was not yet in a place to know what she deserved, but because a civil suit would require years of litigation and ongoing contact, and I had decided I was done spending my time on Craig and Linda Hooper. The title lock remained in place. The institutional trustee remained in place. The will remained, as Gerald had amended it. Everything I had built in those quiet weeks between November and February stood exactly as I had built it: legal, documented, unassailable. Craig entered a guilty plea to a reduced charge in June and was sentenced to 18 months probation, a fine of $22,000, and mandatory restitution, though there was nothing in the end to restore, because nothing had been taken. The attempted exploitation had been stopped before completion, and the sentencing reflected that. Philip Dutton received a 2-year license suspension from the Department of Commerce, and his firm was placed under a consent order requiring supervision of all future acquisitions. It was not a spectacular punishment. Gerald had warned me it might not be, given that no transfer had occurred, and Craig's plea was to a reduced charge. I had expected that, and I was not disappointed. The law does what it can with what it has. I had done what I needed to do. On a warm evening in July, I walked to the end of Clover Lane and stood at the corner for a while, the way Harold and I used to do on summer evenings when the neighborhood was quiet and the light was long. The maple was full and green. The house was mine, exactly as it had been, exactly as it would remain. I was, I thought, all right. By the time the leaves turned that October, the first real autumn after all of it, I had made several changes to my life that I might not have made otherwise. I had the kitchen repainted. This sounds like a small thing, and it is. But the kitchen had been the same shade of off-white since 1998, and I had been meaning to change it for years. I chose a warm green, the color of good sage. I painted it myself over 2 weekends with the help of Diane Ostrowski, who was a better painter than I was, and who talked the entire time, which turned out to be exactly the right kind of company. I started taking a Wednesday afternoon class at the community center. Watercolor, which I had never attempted, and which I was not particularly good at, but which occupied my hands and my attention in a way that was deeply satisfying. 3 of the people in that class became, over the following months, what I would call real friends, people I spoke to honestly about real things. Eleanor Marsh and I had dinner together every other Friday. I had learned to think of her less as a neighbor and more as something closer to a colleague, someone who had navigated similar terrain and come out intact. I traveled for the first time since Harold died. A long weekend in October, a bed and breakfast in the Hudson Valley. I drove alone. I ate alone at a small restaurant on the second evening, at a table by the window with a glass of wine and a novel, and the solitude felt like something I had chosen rather than something that had happened to me. And the difference between those two things was everything. I thought about Linda, of course. In the first months, the thoughts had edges. By autumn, they had become something flatter and more neutral. What I knew was this: I did not miss the version of our relationship that had existed in the 2 years before that November night. I had been performing contentment, telling myself that the hovering was love, that the pressure was concern. The real relationship had ended before I'd known it was ending. As for Craig and Linda, I received information about them secondhand, mostly through Eleanor. Craig's probation prohibited him from engaging in real estate transactions in any capacity. He and Linda were living in a smaller apartment on the east side of the city. Linda had left the marketing firm, whether voluntarily or not, I didn't know. Their marriage, by the accounts that reached me, was not prospering. The gap between what Craig had told Linda and what he had actually done had not closed with time. I heard once that Linda had tried to call me. She had called the landline, and I had looked at the screen and let it ring. Not with hatred, but I was not ready, and I had learned to take my own readiness seriously. I planted tulip bulbs in November, along the front walk, the way I had been meaning to for several years. They would come up in April. I would still be here to see them. The house on Clover Lane was mine. The kitchen was green. The Wednesday watercolor class met at 3 o'clock. I was completely all right. I told you this story the way it happened. No softened edges, no tidy conclusions life doesn't actually provide. What I learned: trust yourself. When something is wrong, you already know. The voice that woke me at 3 in the morning was not panic. It was intelligence. And protection is built in advance, not in crisis. If you are the older person being managed, being pressured, being quietly measured for what you're worth, your clarity is real. Your rights are real. Act before anything is signed. What would you have done in my place? Leave a comment. Share this with someone who needs it. Thank you for listening.